This is a presentation by the Scottish Law Agents Society, primarily for the purposes of the Continuing Professional Development Programme and specifically also for the Trainees Continuing Professional Development Programme. If you wish to register your attendance at this podcast for these purposes, you should now pause the presentation and you should send an email to the address shown on the screen stating the subject matter, podcast COVID conveyancing login, and in the body of the email you should state your firm name or address.
Good morning, good evening, good afternoon, whenever it is you're watching this webinar. I'm very happy to say hello to you. Hope that you're able to get some enjoyment out of today's talk. We were hoping, obviously, that we could be able to by now have had actual seminars, but this is what we're limited to, and we have to make the best of it. COVID conveyancing, what a topic. I would describe it, and others have described it, as perhaps miserable, frantic, feeling behind all the time and not in front of what's going on because there's been so much of it. So we're all very, very busy. We're all using huge workloads. We're trying to balance it all, and it's not easy. And it's not easy to get in front. One of the things that we can do to help ourselves is to be a bit better at doing missives. And that's the topic that we're talking about today. When I qualified, which is 1978, so I'm giving you quite a clue as to my age here, I qualified as a conveyancing solicitor. I had to choose, and I went for conveyancing at that stage. That was quite early to have to make changes like that, you know, that you were going for a particular topic rather than being a general solicitor. In those days, mortgages, missives had 5 clauses to them, approximately. You had price, you had date of entry, a good and marketable title, which was right at the heart of it, extras, and time limit. If I've missed something out, let me know, but answers on a postcard, please. But those were the main ones that were mentioned in missives in those days. And it was quite straightforward when you were concluding missives, etc. Somehow it all went wrong. Somehow we seem to take to ourselves more responsibilities and more difficult, complex issues on board as being something that we had to deal with. And suddenly there was an explosion of clauses. And it was not infrequent in my later days to receive an offer of 6 pages length with detailed clauses, and me having to issue a 5-page qualified acceptance, and perhaps the missives comprising 5 or 6 formal letters before you got to conclusion. This served nobody. This was a vanity project of ours, that we were all trying to do the best and to get the wording that we wanted into our contracts, not realizing that actually we were making the thing extremely complex for ourselves, and also, and importantly, very complex for our clients. If you can imagine us having to struggle with a 6-page offer and a 5-page qualified acceptance and 5 or 6 formal letters making up the conclusion, how do you think the clients felt when they were trying to work out what on earth they'd signed up for? It was very difficult, and I don't think we earned any brownie points for it. I was one of the people who was very critical of the standard missives introduced by the Law Society many years ago. It was a project which had a great ambition behind it. I'm absolutely sure of that. Unfortunately, it was botched, and there was a mistake in it that meant that the whole system couldn't work. Basically, the important thing about registration of title is that you get a land certificate with no exclusion of indemnity, now warranty. But that was the important point, and that was missed out. And it said that you couldn't amend the clauses in section A, in where this clause was. So you couldn't add in the words exclusion of indemnity into it. So the project was flawed right from the word go, and it was a bit of a mess, and it was shot down. I kept feeling that I had perhaps allowed the baby to be thrown out with the bathwater, And as we were struggling with these long qualified acceptances, etc., I realised that I should join a project that was suddenly announced that they were going to have a Glasgow Standard missive. And I felt I needed to do this because we had thrown the baby out with the bathwater previously. It was time to try to write it and get it right. And so we joined the project, and eventually we've ended up, of course, with now not just regional standard missives, but a nationwide standard missive. And the whole object of it is to make your life easier and that of your client easier. That's the point. Once you realise this and you realise how you're practising, it should affect how you deal with doing concluded missives. Basically, your peers have come up with standard clauses that most of the profession can live with. So when you're trying to change it here and there because it's your pet qualification, or you don't quite like that wording, you'd like to change it slightly, it's a bit of a vanity project. Really, try to stick by the standard clauses, offer with as few amendments to your offer, and qualify with as few qualifications. And this is the whole idea behind it. So I'm trying to, first of all, say to you, look, here's why we do missives the way we do. We don't want to go back to that. I have loads of solicitors will contact me and say, well, you do something about these lawyers who put in 10 qualifications in their offer to their own style of offer, that they don't like this and they've changed this and that. Can you do something about it? And the point is, I can't do anything about it. But I urge you to get onto your colleagues and tell them to do something about it. That's what you need to do. You need to point out, look, you don't need to make these qualifications. So why are you doing it? Question why you're doing it and make them as few as possible. So with a style missive, you've got one style of offer. You do not have umpteen different styles coming in. That's a great blessing, and that's what you need to have. If you're trying to make a qualification, for example, to delete something that's not applicable, why are you doing that? Why delete the clause that says about crofting? Well, we know it doesn't apply, but why do you have to actually have a separate clause deleting it? You question yourself about this. Think about your motives here. And are you making this easier for your client and your fellow colleagues, or are you just being plain difficult? I would urge you to examine your motives, please. A lot of people also have the clause in about if there's been a sale at an undervalue or a gift within 5 years, well, basically there's not been one, but there can be ones. And some people put in special clauses to deal with that. Well, it's part of a good and marketable title. We've already had that established when we set the thing up, that you don't need to qualify in that regard, because if there's a doubt in the title, then you're entitled to have that removed. And how do you remove it? A statutory declaration or an indemnity policy. It can be sorted. But that's how you deal with it. You don't need a special clause to deal with it. It can just be agreed between you because it's part of trying to make the good and marketable title. So these are the sort of things that you want. A lot of people also put in qualifications that say things like, all letters must be formal. And the laugh that I get sometimes from it is that the people who've put the offer in haven't actually abided by the rules of putting in a formal letter. Yes, it's witness, but they haven't got the name of the witness and address. They've forgotten to put these essential details in, so they've actually breached the condition, the very condition that they've put in, that all letters must have this. And what does that do? See, it's doubt. It is a bit silly. So, you don't have to have all letters in formal style. Most people do because it's easier to set up after the event. But how many of us have to go to court to prove this? Yes, it makes it probative if you follow the rules, and that's good from your point of view, but usually you can prove these things without difficulty. So it's not really a problem. So again, just question why you're doing these changes here. So I think now if we want to go to the next slide. So let's go to the slides. First of all, missives. What does the word missives mean? Well, a definition in the Collins English Dictionary of everyday use is either one, a formal or official letter, or a formal word for a letter. Next slide. However, a legal definition is the letters between the parties or their solicitors forming a contract for the sale and purchase of land by private bargain. Now, that must be created in writing, which is what we mentioned previously, and although it's normally probative, that is not required. And that's the Requirements of Writing Act. Slide 3. What do missives normally comprise? Well, they can be just an offer and acceptance. That is not very often these days, but it should be possible on occasion. Or missives can be an offer with a qualified acceptance or several qualified acceptances and then an acceptance, which is by far the most usual version that we have. However, there is a third way of doing missives, which is not to be commended, but just so that you keep it up your sleeve in case you need to know about it. And that is that you have an offer and there may be some qualified acceptances going back and forward, but you didn't ever get an acceptance. But there have been actings. What do I mean by that? Well, what I mean by that is that you may have all worked on the basis that you thought missives were concluded. And so what has happened is that you have been able to cure the omission of not having the final letter in accepting. But more on that later. Next slide. For missives, there has to be agreement. There needs consensus. An acceptance must be unqualified and meet the offer or a qualified acceptance. There must be consensus in idem before the contract is binding. Introducing qualifications or new conditions constitutes a counter offer, which itself requires acceptance by the original offerer before the bargain is complete. Next slide. A word about time limits and withdrawal. An offer that doesn't have a time limit can be withdrawn at any time before acceptance. If an offer contains no condition as to time, then it will fall, if not accepted, within a reasonable period. And what is reasonable is a matter of circumstances. If an offer has a time limit, that does not prevent its withdrawal within the period stated. So you've given a deadline of 5 working days, but something changes and you need to withdraw. So an offer with a time limit does not preclude that. However, it does preclude acceptance after the expiry of the time limit. Next slide. The second slide on time limits. A time limit can be so expressed that it constitutes an obligation not to withdraw it within the time specified. Now, that is not a good idea. Whatever else you do, do not have that. That would very seldom be in your client's interests to have something like that, an obligation not to withdraw. An offeror will usually wish to be able to withdraw at any time. And if you look at the provision contained in the Scottish Standard Offer, then clause 2 is this offer, unless earlier withdrawn. So those words
at this
are
point,
in there.
in order to have your attendance at this podcast accredited for CPD or TCPD or other official purpose, you're required to pause the delivery and send a further email to the address shown, this time with the subject matter podcast COVID conveyancing email 2.
Hi, so again, looking at COVID conveyancing, I want to go back to something we mentioned at an earlier stage regarding actings of the parties and how these might cure deficiencies. And that brings us to what I call statutory homologation under the Requirements of Writing Scotland Act 1995, Section 1. There's a number of subsections dealing with that. I'll slightly paraphrase so that you get the meaning of this. Subsection 3, where a contract not properly constituted in terms of the formalities, but one of the parties to the contract, which we'll call the first person, has acted or refrained from acting in reliance on the contract with the knowledge and acquiescence of the other party to the contract, who's the second person, then the second person shall not be entitled to withdraw from the contract, and the contract shall not be regarded as being invalid on the ground that it's not properly constituted if the condition set out below is satisfied. And that subsection 4 says the condition referred to in subsection 3 is that the position of the first person, A, as a result of acting or refraining from acting as mentioned in that subsection, has been affected to a material extent, and B, as a result of such a withdrawal as is mentioned in that subsection, it would be adversely affected to a material extent. And very importantly, it says this replaces the rules of law known as rei interventus and homologation. So something to realize from this is that rei interventus and homologation, as the way they used to be, have gone, because they've been replaced. They've been replaced by Section 1. So what was done previously is not now available. All you've got is what's under Section 1. But in effect, it is a statutory redefining of it, and it's really a defining of homologation rather than rei interventus. So that's why I put the heading here, statutory homologation. I think that's what we have here. What we're dealing with on the slide is what I would describe as a deemed acceptance. So you can have an acceptance that's been deemed to have taken place because the parties have acted in reliance of the contract. And also there's been what I would describe as a crystallization of the missives. In other words, the missives, when you settled the transaction and they weren't completely concluded, have actually crystallized in a way so that they're now crystallized and they form the contract as at the time you settled it. So I think what I'd like to discuss from that previous slide is just the whole point of this. What are we talking about? For example, if you had sent an offer, qualified acceptance came in, a further qualified acceptance was sent out with a time limit, but you forgot, or somebody forgot to send an acceptance concluding the bargain. But on the basis of all of that, you settle. The price is paid and you get entry and all the rest of it. So actings have taken place on the strength of the contract, and the contract has effectively crystallized on the basis of the terms of the offer and acceptance and qualified acceptances to date, as if there had been a final acceptance concluding. That's an example of the sort of thing I'm talking about. I did have an example myself of this concept many years ago, so before this act came into force, and it was to do with an offer of lease that had been sent out to a client or to a party offering to lease the property to them, and on the basis of the offer, but with no acceptance, the person moved in and started to occupy the property and pay the rent, etc. It was quite clear that the parties had entered into a contract under the former rules, and basically had homologated the positions because both parties acted on the basis of the contract. In other words, the terms of the offer, without any qualifications, had been accepted by the party moving in and continuing on the property. It's quite funny, I did have a case of this, which was before the discipline tribunal, and not the discipline tribunal, this was a conduct committee of the Law Society. Now, I don't appear before them, everything's done by written representations, but the charge was that my client had allowed a situation where missives were not concluded. And the client was saying that they had been prejudiced because missives had not been concluded. And it was of the kind of description that I was mentioning to you, that there had been an offer, qualified acceptance, and then no final acceptance. And this was being seized on as some horrific offence by the solicitor. Now, I admit that normally you ought to be sending an acceptance to conclude the bargain. Everybody knows that. But the hoo-ha that was being made about it was, I felt, over the top, because the client was not left in a position where he didn't have a contract. He did have a contract. And his point was that because he didn't have a contract, he was having difficulty getting the other party. He would have difficulty suing them and taking it further. Well, the point was that in that same action, he could have just asked for the sheriff to declare that that there were missives under these rules of rea interventus or homologation. It wasn't going to really make much of a difference. And really, that was important to point that out, because it suddenly took the thing from being in one category to being downgraded to being, well, you didn't quite do it right, but come on, you still got for the client the result he wanted. You did have a contract. Those were the terms. It was a deemed contract. There was crystallization of missives, and therefore this is where you got to for the client, and you'd done right by him. So that was an important thing to know. Just incidentally, it was quite amazing that so many members of the committee had no knowledge of this. This was new law to them. They didn't know about it, which I thought was quite staggering, that a number of members of on that committee that were dealing with it had no knowledge of this conveyancing point. And I found that quite strange. It's one of the reasons I'm actually covering it today, because I think there is quite an absence of knowledge of this particular point. Next slide. I would now like to speak about the art of standard missives. And I hope that most of you will learn this off by heart, because it is really the important point here about standard missives. The art of standard missives is not how many changes you can make to the style, but how few. I think if you, in your professional career of doing missives, keep that in mind, you'll not go far wrong. This is what it's all about, keeping to the style and not making too many amendments, keeping them as few as you possibly can. And it really sums up all of the guidelines that I'm going to mention later. And we'll just come to those now. Next slide. Now, there are guidelines which are contained in the Practitioner's Guide. The Practitioner's Guide is available widely on the Law Society website, as well as on the Glasgow Conveyancers Forum and Edinburgh Conveyancers Forum websites, and I think the faculty website as well. So they are widely available. When I ask people about the Practitioner's Guide, virtually no one has read it. So that's why I try to bring these things to life by talking about them at conferences and trying to highlight them. But when you ask people, virtually no hands go up as to anybody admitting to having read the Practitioner's Guide. Don't know why that is. I must have made it incredibly boring. However, there we go. What are the guidelines? I'm actually changing them. So the ones that are currently there are going to go, and I'm going to replace them with the ones that you're just reading just now. The first is that the offering solicitor should endeavour to submit the offer in the standard style referring to the standard clauses with as few changes as possible. And the second is very like it, that the selling solicitor should endeavour to qualify with as few qualifications as possible. And obeying both of those should greatly cut down the amount of work and the effort taken to conclude missives. Next slide. So what is the aim of all this, of the guidelines? The aim is to conclude missives with either a de plano acceptance or at most one qualified acceptance before an acceptance. Now, that might sound ridiculous that you can get a de plano acceptance, but I can tell you I've done them, and it is the most satisfying feeling in the world when you just send a de plano acceptance. It frequently leads to the other lawyer phoning you up and saying, "What on earth's happened here? I wasn't expecting an acceptance. How come you've just sent a straight acceptance?" And it's because I don't need to qualify. I was selling my parent-in-law's house, and I was quite aware of it was a council house, that they'd done no alterations, that they'd done no work to the property, whatever, that there was nothing adversely affecting the property or likely to. All very straightforward. So I sent an acceptance concluding the bargain. And that was just, as I say, tremendously satisfying because I didn't need to do it. I thought about it and thought, you know what? I don't need to qualify this. I can do this. So I sent an acceptance. It was an incredibly complicated transaction with lots of other things that arose out of the title and stuff. But the actual conclusion of the missives was very, very simple. Next slide. Fourth guidance is that goodwill is required from both the purchaser and seller to keep the missives adjustment period to as short a time as possible. I've added this bit in because I think in the present COVID climate, it's a good idea that a draft qualified acceptance issued after receipt of the offer will greatly assist things. And I'm also saying that ideally missives should be concluded within 1 week of the suspensive conditions being purified. Now, initially, when that was written, it was done on the basis that we conclude missives within 1 week of receiving an offer. But of course, because offers suddenly had to be subject to sale or subject to loan or survey or whatever, this was never going to be possible. And so things changed. So what I've said is, as soon as you get your suspensive conditions out the road, we should have missives qualified, and a draft qualified acceptance will help you do that. In other words, if you have an offer and you've got things that you're going to have to raise with them and disclose and to talk about because the title isn't perfect, or there's some title mineral reservation clause or some other problem that you want to highlight, then raise it in your draft qualified acceptance at an early stage and ask the other side to comment and to approve the revisals or let you or give a response about what they think about this. But by doing a draft qualified acceptance, you're getting things out there so that people know how you're dealing with it, and it's done at an early stage. And it should assist so that you're not having to then rethink it all again when you've got the suspensive conditions out the road. You've done all the thinking beforehand. Next slide. One thing to warn your client about is that if the offer is subject to survey or subject to loan or subject to sale, then their offer is less likely to be accepted than one which is not so qualified. That's not encouraging the client to do away with the clause because they don't really want to have to do this. It's not advisable to do it if you're truly subject to these things. But it's just so that you've managed the expectations of the purchaser, that if they're offering at a closing date, if their offer, if they can get it as clean as they can, that's good. But if it's subject to things, then there's nothing you can do about that. They just have to make sure that their offer is subject to these items, and that it might not be as acceptable as another one, even one that might be slightly lower in price. Next slide. A recommendation here is that when your firm is a member of an SPC, so you're an estate agency as well as a lawyer, your property schedules might contain the wording, offers are invited in the style of the Scottish Standard offer, and incorporating the Scottish Standard clauses, whichever edition is current at the time. And that's useful. It was more useful in the past because people were getting offers of all sorts of different types. So by putting in this specific thing, if somebody put in an offer that wasn't in the style, you could say to them, well, you haven't put it in the style, I'm not happy. You'll have to re-put it in, or we're going to qualify in that regard. Next slide. If the offering solicitor doesn't use the Scottish Standard offer, the suggestion is that it's met with a qualified acceptance, which, one, accepts the offer, but only to the extent of price, entry, and extras, if indeed these are so agreed, but then going on to delete all other clauses and incorporate by reference the SSC edition 3 at the moment. So it's no surprise to people when they get this back that this is how you're dealing with it, that you're going to stick to this because most lawyers are using them now, and almost 100%, I think, are using them now. So you want things simple. And then there used to be a problem with conflict of standard offers because we used to have regional styles for every region, but it's not a concern with an all Scotland style. We've now got a style that applies throughout, and as I say, most people are using it. And you'll find that the Scottish Standard clauses are easily accessible on the Law Society website, and I've also referred to the Glasgow Conveyancers Forum and to the Edinburgh Conveyancers Forum and the Royal Faculty of Procurators in Glasgow, which have all these styles on. And the Practitioner's Guide and the Client Guide are also available on that website. Now, see, we've gone into the next clause, so I'll just go to that one as well. This is to do with the use of clauses and the Client Guide. Basically, when we set this up, we wanted people to use it. So we said it was available to use by any solicitor. So any solicitor can use it. Of course, I suppose if estate agencies started to do it, they might use it too. Well, nobody's going to take any action about it if they do, but they are available for use by any solicitor. You are entitled to edit the wording of the Client Guide if you feel it can be improved. And that is something that you might consider. I'm not aware of many firms doing that, but you are entitled to edit the wording, so you can do that if you think you can. And importantly, you're free to add the firm branding to the Client Guide. At the bottom of this slide, you'll see the Mitchell's Roberton stamp there. Well, I put that onto the Client Guide and save it as a document, and that gets sent out to clients anytime that we're buying and selling. Frequently, I'll be sending out a letter or an email rather, that encloses a copy of the offer that we're submitting, a copy of the Client Guide, my letter of engagement, and the terms of business. And it's all done on day one in one email. And by sending that out at the beginning, you've told the client the terms upon which you'll be offering. Now, in fact, quite often the client will be coming to you just for a quote. So you can be giving them a quote, send them out the Client Guide then. Send it out at the beginning, telling them, this is the Client Guide. The clauses are in section 3 of the guide, and the explanations are in section 4 of the guide. So that the clients are aware of what is going to be applying to their contract at a very early stage, and they can't say you didn't explain it to them. The question, of course, arises, what's the effect of not using the Client Guide? Next slide. The Client Guide is a very helpful document because if you look at it, section 1, part 1, talks about the purpose of the clauses. In the same way I've done today, it sets out for the client why we're doing it this way. So if you're not doing it the way that's outlined there, they're going to be wondering why. If you're putting in loads of qualifications that make no sense, they're going to be wondering why. And I've also explained, however, that our purpose was frustrated because of the Scottish missives chains, because there are chains that have developed as a result of that. And that explains this to the client to manage their expectations that, unfortunately, because of suspensive conditions, things are not as easy as they used to be. Section 2 sets out the Scottish standard offer, and Section 3 sets out the Scottish standard clauses. And Section 4, explanations of the standard clauses. Now, when I'm writing to a client, I will normally say that I am offering, here's a copy of the offer, and the clauses are contained in Section 3 of the client guide attached, and the Section 4, there are explanations of the Scottish standard clauses, so that is all set out for the client. Now, I do tend to talk my clients through at qualified acceptance stage all the changes that are made to that, but I tend not to give much in the way of explanation when sending it out by way of an offer. But it really cuts down your work. And I want to just go back to that. What is the effect of not using the client guide? Now, if you don't send it out, if you, for example, don't send out any of the clauses, then you're not explaining things to your client properly, and you're going to be faulted for it. If there's a client guide which is available to all clients to read, and you don't send it out, then you're going to be asked the question, why didn't you do it? Because people will look at current practice and they will say, well, what do most lawyers do? Well, most lawyers send out an offer with a client guide, which explains the position. So if you're not doing it, then you're not acting according to current practice. And if the client says, well, he never explained that to me, but it's all explained in the guide, you can't take the credit for that. So it's not even enough to send the standard clauses themselves. If you send the client guide, you've got the explanations as well. So that is what's protecting you. Now, in my work with the Legal Defence Union and going before them regarding, before the Law Society, there are questions being raised about things, and the SLCC themselves have referred to the client guides in the past in dealing with things. They'll refer themselves because they know it exists, and they'll say, well, you never sent that out. So that wasn't an adequate service. That was an inadequate service, patently, because you never explained anything to the client. Oh, but I said to them on the phone, I explained this all on the phone. Well, where's the file note? And what's the detail of that? How detailed is it? If you've got a client guide, you've got back protection. And I would suggest that you should use the client guide as much as you can, because it does help you. And as I say, if you don't think the wording is particularly well worded, then make it better. A word of warning about trying to make it better, just make sure you don't make it worse. Because if you start explaining it in a different way and it doesn't make sense, or it leads to an adverse position because you haven't thought about it properly, then you might be liable for that as well. People are looking at the standard wordings here, which are there for your protection. And if you use them, you're going to get protection. If you don't use them, then you're going to have to justify your position as to whether it was justified or not for you to make the change. And I think that goes with some of the changes that can be made to clauses. You know, it's not the first time that I've seen people put in an offer or a qualified acceptance, which have made their position worse because the wording wasn't as clear and they missed something out and they didn't follow the standard wording, and therefore they ended up making a worse position, which I'm sure they didn't intend, but I wasn't going to point it out to them. At the end of the day, they've made it worse for themselves. And if something came as a result of that, then there's a problem. So using standard clauses, using the client guide, abiding by them makes total sense. and should protect you in your career going forward. And please do make it easier for the other practitioners at the other side by exercising the art of standard missives to your best ability. Thank you very much.
That concludes the COVID Conveyancing podcast, and you should now pause the recording and take on board the final slide now in front of you. If you wish to have your attendance at this podcast accredited for any official purposes, such as continuing professional development in the CPD or TCPD programs, then in order to protect the quality and reputation of your training, then there are certain essential requirements. First of all, you require to have sent the 2 emails which were identified during the delivery of the podcast. Now you require to undertake the 2-part assignment identified on the present slide and to return this with an email to the usual address within 7 days after the date of your initial email given at the beginning of the podcast. Now, if these requirements seem unduly bureaucratic, we have to apologise, but we see them to be essential to protect the integrity and reputation and quality of your training. And we see this as also as a protection of the interests of the profession and of the public served by the profession. So we look forward to receiving the return of your assignments and also to your own future interest in our training programs, whether to undertake further training or if you would wish to share the benefit of your wisdom and practical experience with your professional colleagues, you might wish to consider creating your own training program. Thank you very much for your interest.